Okay, so yes, yesterday I told you guys about the subject that I'll be dealing with. So kindly, mute your mic, please, because there might be background noises. If you have any question, then unmute and ask. Otherwise, keep it muted. Okay, but keep your video on though. Don't worry. Tomorrow I'll be in a place where I will have little embarrassment displaying the background, its construction site, but it's fine. We know that we are in in troubled times, so it's fine. No issues. No one's going to judge you. So yes, I told you guys yesterday that we are going to learn about law of tort or law of torts, whatever you use. Now, what is a tort? Okay, what does tort mean? Okay, we don't really need genealogy of a particular word, okay, to know what it really conveys, but it's helpful nonetheless. Okay, so it's a Latin word. Okay, it emerges from evolved from a Latin word called tortum. Okay, tortum, tortum, and that essentially means twisted. Okay, something that is not straight, something that is twisted. Okay, but then it sends a wrong message though. As you know, in today's time, we do not discriminate between what is considered as straight and what is considered as not straight. Okay, so yeah, I'm definitely not talking in that term. Okay, not in terms of sexuality. No, it's just actions. Okay, actions which are not okay, actions which are twisted, actions which are not straight, but not in that other sense of the term. Okay, I'm definitely not normalizing being straight. Okay, so yes, tortum essentially means acts which are twisted. Okay, yes, there must have been a time, okay, until very recently, until homosexuality was decriminalized, one would consider homosexuality as being twisted. Okay, but I'm not referring to that. Do not be under any such misconception. Okay, so the word tortum essentially means something that is twisted. So an action that is twisted is something that is proscribed by the law. Okay, proscribed, not prescribed, proscribed, prohibited by the law. Okay, why, we will see. Okay, so the word tort started, emerged, germinated from that previous, that Latin word known as tortum. Okay, so what does tort mean to us, the lawyers? Okay, what does the word tort mean to us? Okay, so it is a kind of wrong. Okay, it is a kind of wrong. When I say wrong, what does it mean? Wrong is what is opposite to right. Okay, so it is something that is not right. Okay, an action that is not right. Okay, or an action that is an infringement of a right. Okay, I'm using the word right in two different senses. Okay, right, in the first sense, I meant something which is not morally allowable, or something that is not legally allowed, okay, or morally allowed. Now that creates question, does legal and moral overlap? We will come to that later. Okay, so I'm using the word right in two different senses. Okay, so what is a wrong? A wrong is that which is not right. Okay, so right could be used in two different senses then. Okay, the first sense is your rightness of your action. Okay, your action is allowed by the law, or your action is allowed by rules of morality. Okay, it could be either of that. Okay, or it could be that it is against someone's right. Okay, when I say against someone's right, I'm using the word right in a different sense. Right, maybe in the sense of a claim right, in the sense that you claim that someone does or does not do something in regard to you. Okay, someone does act, okay, or does not abstain from doing something in regard to you. Okay, so that could be a case of right. You keep saying that I have right to vote, I have right to walk. We will break that down later on further, but you use the word right in that sense, don't you? You say that I have a right that you pay me ₹100, I have a right that you give me back my mobile. So you use the term right in different senses. Okay, so essentially we are trying to define tort in that sense. Okay, so what is a tort? It says a wrong. Okay, when I say wrong, what is it? Something that is not right. Okay, so a wrong which is independent of contract. Okay, so a wrong that emerges not from a contract. Okay, so what is a tort? What is the definition of tort that I just told you in simplest of words? Can anyone unmute and tell me?
A wrong which is independent of contract.
Okay, a wrong which is independent of contract, as simple as that. Okay, now you will be asking me, sir, what is contract? Okay, now contract is a different area of law, okay, separate from torts. Okay, now contract is essentially the law of contract. Okay, you have Indian Contract Act. Okay, the law of contract is based on the principle of principle of promises ought to be kept. Okay, if you make promise to someone, okay, then you ought to keep your promise. Okay, law of contract is based on this principle that promises ought to be kept. Do you understand me? So for example, I promise to deliver certain bags of cotton to you at a certain place in exchange for you paying me rupees 1,000. Okay, so I promise to deliver certain goods, and you promise to pay me certain money consideration. Okay, so there is mutual promise from both the sides. Okay, so that leads to an agreement. An agreement that is recognized by the law is a contract. So that's what contract is. Okay, so law of contract is based on mutual promises, and based on this principle that when promises when made ought to be kept. Okay, so we will talk about these principles later on in jurisprudence. Okay, why that principle exists. Whereas you have tort, tort is a wrong. Okay, violation of breach of contract will also be a kind of wrong, but tort is not that kind of wrong. Okay, tort is a wrong which is independent of contract. So tort is not based on promises. Okay, tort is not based on the principle that promises ought to be kept. It's a wrong of a different kind. Still, it's not sufficient for you, is it? It's still not sufficient for you to identify what is tort and what is not tort. But you can clearly make a distinction between what is a tort and what is a contract. Is that clear so far? Is it clear? If it is clear, then tell me. I will proceed. Okay.
Yes.
Okay.
Yes, sir.
Okay. That's good. Okay. So once the wrong is committed, okay, once the wrong has been committed by the defendant, okay, so tort is essentially civil wrong. One more. Arnab, please turn off your mic, please. Yes. So tort, another thing that I would like to add, I said tort is a wrong. Okay, tort is not criminal in nature. Okay, an act of tort is not criminal in nature. It's a civil wrong. So one more thing that you would like to add. Okay, tort is a civil wrong. Okay, so if you have to institute a civil suit, okay, before a civil court. Okay, so yes, it is a civil wrong. Okay, so if a wrong of that sort is committed, okay, it gives rise to what is known as civil remedy. You do not have criminal remedy, but you have civil remedy. Okay, so under section 9 of CPC, a matter of claim can be taken to a civil court. So do you understand? It's not a criminal matter, it's a civil matter. Hence section 9 talk about institution of a civil suit which is of tortuous in nature. You can institute before a civil court. Okay, so and then ultimately the third important aspect of tort is,
sir?
yes.
So section 9 of what?
CPC, I'm sorry, Code of Civil,
CPC.
CPC, Code of Civil Procedure Code. Okay, so let me read it out to you. Just a second, I'll find it quickly. Okay, so section 9 of, I'll just quickly drop it here in the, sorry. So yeah, I found it on Google. You guys can click on it. It says courts to try all civil suits unless barred. Okay, so it could be barred for many reasons. Okay, it could be jurisdictional bar, or it could be time, a bar imposed because of time, etc., etc. So it says the court shall, subject to the provisions herein contained, have jurisdiction to try all suits of civil nature, excepting suits of which their cognizance is expressly or impliedly barred. Okay, so that much is sufficient for us for now. Okay, so it says that all suits of civil nature. So a suit of the nature of a tort is a suit of civil nature. Okay, is that clear? So you can take it before the court, okay, under this particular provision of Code of Civil Procedure or Civil Procedure Code. So yes, so I said that tort is a wrong which is independent of contract. Okay, it gives rise to a civil remedy. So you will have a civil remedy, not a criminal remedy. I haven't distinguished between civil and criminal remedy. We will do that in the course of time. Okay, and thirdly, for the same, you can seek compensation in the court. Okay, from the defendant. Okay, so you can seek compensation from the defendant in the court. Okay, so this is the broad definition of, just for the sake of introduction, this is the definition of a tort. Okay, so I hope this is clear. Okay, it's a wrong, it's a civil wrong, it's not like contract. Okay, it gives rise to civil remedy, and what's the remedy that is available to you? It is compensation, from the that you can seek from the defendant. Okay, so that's tort for you, as simple as that. Okay, now I told you that the principle of the contract is based on the principle that promises ought to be kept. So tort must also be based on certain principle. So what's that principle? Tort is based on the principle that you shall not harm another person. Okay, you will not harm another person. Thou shalt not harm thy neighbor. Okay, so we call tort law of neighbors as well. Okay, the responsibilities that you have towards your neighbors. Okay, I'm not saying your neighbors like living adjacent to your house, anyone who's around you. Okay, so it's based on this principle that thou shalt not harm thy neighbor. Okay, so law of tort is essentially based on that principle, whereas contract is based on the principle that promises ought to be kept. So is it clear so far? Okay, very easy. This is a very easy subject. If you keep up, then you will score very good marks. Okay, so yes, I said a wrong. Okay, wrong could be what? When I say wrong, it is some factual, it's a certain factual circumstances. Okay, certain fact happens, and that is considered as wrong. Okay, and of course it leads to violation of some right. Okay, so what could be that wrong? Okay, so that wrong could be in the nature of an act or in the nature of omission. Okay, so what does act or omission mean? Act basically means that you ought to act in a certain way. Okay, you ought to act in a certain way, that you have to exercise due diligence. Okay, you have to exercise a duty of care. Okay, so something like that. So for example, if you were a bus driver or a car driver and you are driving rash and negligently on the road, you have a duty not to drive rash and negligently, and at the same time you have a duty to drive carefully. Do you see it? So you have a duty to act in a certain way, and also duty not to act in a certain way. So there are two different things here. Okay, so one is act, the other one is omission. Okay, so this act or omission, okay, can prejudicially affect certain private legal right. Okay, so your act or omission could prejudicially affect someone else's, okay, the plaintiff's, okay, private legal right. I'm not talking about public right though. Okay, I'm talking about private legal right. Okay, so for example, I have a sorry, I'm very sorry. Sorry. So I have a, so for example, I have a right to privacy. Okay, that's my private right. Okay, my privacy is not to be infringed. Okay, I have a property. I have a right that someone does not trespass my property. Okay, that's a private right. Okay, so there could be many different kinds of private right. I have a right that my character, my reputation is not slandered. Okay, so these are rights of private nature. Okay, so yes, what is the wrong? The wrong could be in the form of an act or omission that prejudicially affects someone's private legal right. Okay, so I hope you guys have understood here. Okay, Private rights are those which are private in nature, okay? It's applicable to you or a group of person, okay? So yes, an act or omission that prejudicially affects a private legal right, okay? And then if it affects someone's private legal right, then you are entitled to compensation, okay? You are entitled to compensation. So you can go to the court and seek compensation from the defendant, okay? But here's the important point that you guys need to remember, okay? When I talk about compensation, you may ask, what is the amount of compensation? Okay, what is the amount of compensation? Do we have a way of finding out the exact amount of compensation? Well, here is the difference, okay? In case of contract, it is possible for us to identify the exact amount of compensation, because contracts are based on mutual promises, and from those contractual stipulations you can find out the exact amount of compensation to be paid for breach of contract, okay? Whereas in case of tort, there is no such promises, okay? So the compensation that you seek is considered as unliquidated damages, okay? What do we call it? The compensation here is called as unliquidated damages. I will type it if it is. Okay, so do you guys see it? I just typed it in the chat box. It's there. Okay, so the compensation that you seek is unliquidated damages. So what do I mean by unliquidated damages? As it says, okay, you do not know the exact amount, okay? It will be up to the discretion of the court to decide what compensation will be paid to you. That's why we call it unliquidated damages. Whereas in case of contract, it is more or less identifiable. There might be some variation here and there, but it is possible for us reasonable to ascertain what will be the damages provided to you. So that is liquidated, and here in case of tort, the damages is unliquidated damage. Okay, so is it clear? We are gradually progressing towards understanding what is tort. So I hope the general definition that I just gave you is clear to you.
Sir, can you once again define unliquidated damages?
Okay, so for example, I will give you a silly example, okay, simple silly example. So suppose I promise to give you, I promise to deliver a mobile phone to you, okay, on a certain day at a certain time, okay, in lieu of you paying me certain amount of money. So for example, 5,000 rupees, okay? So you, what happens is that you pay me the money, okay? You pay me the money, okay? But I do not give you the mobile, okay? So there is, okay, so this is essentially a sale. I'm giving you a silly example of a sale, okay? So I'm supposed to give you the mobile, but I do not give you, okay? From this fact, it will be possible for the court to find out the harm, the damage that you have, for example, suffered, okay? So it could be laid down in the contract itself, or it could be identified through other means, okay? So from not having delivered you the mobile as I have promised, it might have caused you certain harm of certain amount. So it could be from the facts of the case identifiable for the court to identify what damages, what compensation is to be paid to you from the harm that you have suffered, okay? But in case of, for example, I have entered your property without your permission. So I have trespassed into your property. What is the amount of harm that you have suffered? Okay, it's much more difficult for me to identify the exact amount of compensation to be given to you. As if I were a judge, it will be difficult. Okay, so for example,
damages cannot be calculated.
Yes, it is to be, it's difficult to calculate in terms of money, but it is calculated in terms of money, but it is left to the discretion of the court, okay? Whereas in case of contract, from the terms and conditions of the contract, from the contractual stipulations, you can approximately zero in on the damages, on the compensation to be provided. Now, for example, okay, I slandered your reputation, okay, I said something defamatory about your reputation, okay, it affects your reputation. What's the price to be paid for slandering someone's reputation? Difficult to identify, isn't it? Got the idea? So
Yes, sir.
I promised to deliver certain bags of cotton, okay, bales of cotton to you on a certain day, okay, I failed to respect the promise, okay, as a consequence you suffer certain damages, okay. From that fact, court can ascertain what should be the compensation to be paid, okay. So from contractual stipulation it is possible. I'm not doing the exact calculation here, but it is identifiable. But in all the other examples that I gave you, it's difficult. So for example, you were walking by the street and someone throws a ball, someone drops something from one of the rooms above the street, okay, and you are hurt as a consequence. You take the person to the court, okay, in a civil suit, okay, and seek compensation for the said act, okay, negligence, okay. How will the court determine the exact harm that you have suffered, okay, exact damage that you have suffered? It's difficult for us to put it in terms of money. So the court, in the light of the factual situation, will determine what is to be provided to you, okay. It could be approximately as a compensation for the kind of harm that you have suffered. It could be even more than that. It depends. It varies from cases to cases. So when it gives you an amount of money which is approximately equal to the harm that court thinks you have suffered, it is compensatory, okay. But it could also be possible that sometimes court imposes a damage which is much more than the harm that you have suffered, okay. Then it is not merely compensatory but also kind of punitive, okay. So that is also done, and it's up to the discretion of the court to do so. So I hope this is clear to you. Is it? From the silly examples that we have taken, I hope this is clear to you.
Yes.
So that's yes.
So what is punitive?
Punitive
So
something.
what is punitive?
So punitive something that is of the nature of punishment, okay. So for example, okay, now there are different theories of punishment, okay. I'm referring to one particular aspect of it, okay. So I punish you so as to prevent you from doing something in future, okay. So it's also kind of deterrent for others, okay. It's also kind of telling you that you should not do something like this, okay. If you do, then these are the consequences that will ensue to you. Do you understand this? Okay, it is the amount which is, for example, here given as a compensation is little more than, or could be much more than, the harm that has been suffered, okay, so as to deter or prevent the person from doing it in future. Is that clear? So when something of that nature happens, okay, so for example, I have suffered a harm of ₹100, okay, but the defendant is made to pay a compensation of 300. So it is not equal, isn't it, to the harm that I have suffered. But the additional sum that he has been made to pay cannot be merely compensatory in nature, okay. It has some other effect. So it could be deterrent, it could be whatever. I'm not going into all the theories now, okay. I'll be digressing from law of torts, but you understand, okay. In that case it is little punitive in nature, okay. Is it clear? Is that clear?
Yes, sir. Yes, sir.
Okay, okay. So yes, if the broad idea of what is tort is clear, okay, we will look at a few definitions then, okay. Let's start with the guy who says that it is law of torts, not law of tort, okay. Who's that, if you remember from yesterday? Who said it's law of torts, not law of tort?
Winfield.
No, it's Salmon. Salmon says law of torts. Okay, so he gives a definition of what is tort. Okay, what is law? What is tort? Okay, so he says it is a civil wrong. Someone has Arnab muted. Okay, so Salmon says tort is a civil wrong. Okay, just the way we defined. Okay, it's a civil wrong, not criminal wrong. Okay. It is a civil wrong for which the remedy is common law action for unliquidated damage. So he says the remedy is what? common law action. Okay, now there is a reason why he is saying that it's a common law action. Okay, because tort has emerged in common law. It is not of the nature of equity. So in England there are two branches of law. Okay, one is common law, other one is equity. So tort has emerged in the common law, not in equity. We will make this distinction later, so keep this in mind. Okay, that's why he's saying that a tort is a civil wrong for which the remedy is a common law action. Okay, it's a common law action for unliquidated damage. So you understood what unliquidated damage is. I hope that is clear. Okay, so far our definition fits into Salmon's definition. Okay, and which is, further he says, and which is not exclusively, okay, which is not exclusively the breach of contract. He's saying that which is not exclusively. So there might be cases where tort and contract overlaps, okay, but it is not exclusively a breach of contract. So that's what he's saying. So, and which is not exclusively the breach of contract or the breach of trust or other merely equitable obligations. So as I said, he says that tort is a civil wrong for which the remedy is a common law action. Okay, so common law action, he says that it's a common law action. So he basically saying that it does not emerge from equity, it does not emerge from contract. So I hope this is clear. Is it clear? It's a very simple definition.
Sir, I have a question.
Yes, tell me.
Sir, you have said that public wrong is not a tort.
Sorry, public wrong?
Yes, sir.
Public wrong is a crime.
Yes, sir. Then, sir, if any public wrong harm any particular person more, then can he file under a tort?
Yes, there are so many. So, for example, defamation is a crime, isn't it?
Sir, and one more question.
Yes.
Then why, if the floods come and any in any act of God, then why we sue government and say for compensation?
See, I will go into those questions later on. That is little more specific. We have specific torts. When we deal with that, I will address that question. But let me address the first question, okay? Introductory stage. If I digress, then it will take forever, okay? But we keep that question. I will address when we have the relevant topic that comes up, okay? It's a very important question. But let me address the first question, okay? So the same fact could lead to both tort as well as crime, okay? So for example, someone says something defamatory about you, okay? It could be a defamation, okay, under 499 IPC, okay? Now slander is a kind of defamation and that's a action in tort. Do you understand? Okay. Now if the matter was a criminal matter, what will be the outcome? It could be imprisonment, it could be fine, whatever it is, okay? Got the idea? Is it clear? But okay, you might have also suffered personally, okay? You might have also suffered personally. So it's not sufficient that someone is merely imprisoned, okay, or whatever is the outcome, okay, punishment, okay. You also want compensation. Then you institute a civil suit and seek compensation, okay. Now you know that it is unliquidated because there was no contract or agreement between you and the other person who has vilified you, that okay, if you vilify me, if you defame me, then this is the compensation that you have to pay. That's not the case. It was never determined. So it is considered as unliquidated damages. Is it clear? Okay, so I will address the second question when the relevant topic comes, but that's a very important question that you have asked. Okay, so I think I'm past my time for today. So tomorrow we will continue from where we have left today. Okay, now just a second.